So it's the judgment and not the people that pass the judgment? Is that what you're saying?
Yes, it's the judgment.
But the judgment was made by the people?
Yes.
And the Supreme Court judges that.
But you see, you don't have anything about against 6. It's only one. That one is not now sitting in review. So the other 6 are perfectly entitled to review that decision.
All right, but they then did rule in Kidero's favor, so that has to say something about possible contamination of their ruling, of their judgment, and therefore of the minds of the other judges.
No, you see, unless you have, we can't make that, proposition. We can't make that guess unless we have evidence. We give them the benefit of doubt that there was only one person who was involved in this scheme and the rest were not involved.
All right, so benefit of the doubt. But let's take a look at some of the other conundrums that, Kenyans look at and they say, well, something doesn't quite work here. The JSC itself, as is constituted, a conflict. The Chief Justice sits in the JSC. He's the chair of the JSC. You have Smokin Wanjala, who's also there. Tom Ojenda, who represented Kidero and is his counsel to date. And then you have the subcommittee presenting this to the full committee, that everybody is involved. And Kenyans are starting to doubt whether the JSC itself has even the moral authority to be able to make a decision on this matter.
I mean, there's really nothing wrong. I mean, I think Tom probably made a decision. I don't know whether he participated or not. But sometimes when there's a conflict of interest, you say that, this is my client. My client is remotely involved in this investigation. Can I be excused? And there are many times we excuse people from participating. But the others are perfectly entitled. What the JEC rightly did is when they were constituting the committee, they removed anybody who was remotely connected to the case to participate in that. So once the subcommittee came, then it was brought to the full JSC. I mean, there was nobody who was really conflicted in terms of the members of the committee.
Let me present to you another conundrum that's there, and we were here with the now former CEO of the LSK, and it's about the constitution of the JSC. You were in the JSC. Essentially, you are in the team that hires, fires, and disciplines the judges, yet you continue to present cases before them. Some saying this shouldn't have been the case, and that you should have not practiced for your time at the JSC, that intimidating some of the judges. Do you think that was a conflict of interest on your part?
See, that is the views of very ill-informed people. I have said many times that when I represent lawyers in the JSC, I need to know what is happening in the courts. Sometimes I observe, for example, that there's shortage of judges. There's a lot of inefficiency. I mean, I represent a constituency. It's like saying, you represent, X constituency. Don't visit the constituency. Stay in Nairobi. You need to see how your constituency is faring.
Do you have to do it actively, though, by participating in cases, or can you just observe?
Absolutely, you have to. We go, for example, we go to Kisumu, we go to Nakuru, we have to see how our members are performing. And when we see the problem they have, is the time we bring to the JSC and tell them, there is shortage of judges in Kisumu, there is shortage of judges in Mombasa. So these ideas that lawyers who are practicing should not be members of the JSC is an absolute fallacy.
Well, not necessarily that lawyers who are practicing should not be, but just for your duration in the JSC, that you should not perhaps present cases before
how will I earn a living if I don't practice law?
Surely you have a law firm that has other lawyers that represent you, Ahmednassir. Or are you the only one that goes to court on behalf of all your clients?
It's true that it used to arise a lot when I was there because everybody used to raise it. I'm happy that when Tom goes to court, people don't raise it. But it's not really, it's not a problem.
So for you, it was not a conflict, and the same intimidating figure, like you say, you were pretty rough with some of these people, and then you were now before them.
People also assume judges are imbeciles. That why should I intimidate a judge if he has no issues? There are many judges whose issues don't come before the JSC. I mean, there are so many. It's only when you are crooked, and there are very few, that's the time the JSC comes. So there are many judges out there who have no problem in the JSC.
Okay, when this incident happened with Tunoi and the Ripley case and the SK Macharia case, this was during your tenure at the JSC. Did you feel a need, at that point to censure him or to bring him before the JSC for his conduct? He sat on a case which he had recused himself twice before, and then said he didn't remember the reason he had recused himself and sat on that very case. That was during your time.
Yes, you see, the JSC is not a roving organ. We are not on a drone looking for misdemeanors and felonies committed by judges. A litigant or a lawyer must complain to the JSC and say that this is the complaint I have. The irony is that the lawyer who told him to disqualify is his lawyer.
Feroz?
Yes, Feroz is his lawyer in all these petitions where Tunoi is refusing to retire when he is past 70 years. That is his lawyer. So his lawyer perfectly sees that there was no problem. If there was a problem, he will have complained to the JSC.
Okay, all right. It continues with the conflict of interest that we continue to see. I'd like to switch gears for just a minute now with the emerging details tonight.
Even before we go that, there's the issue of why Justice Tunoi may not be living very soon and why, the case may come to an end. There are three issues. One, on Friday next week, this coming week, his case will be heard in the Court of Appeal. So there's a chance he has lost in the High Court. The High Court told him to retire at 70. He is 72 years old.
And he's appealed.
So there's a chance, that court, if it affirms the decision of the tribunal, or if it affirms the decision of the High Court, may end the whole saga. Because one is the court finds that he should have retired at 50. He's not a member of the judiciary, and there will be no tribunal.
Right.
Secondly, is that I think people are waiting to see the composition of this tribunal, how it is, because there's a possibility, like when they wanted to disband the JSC, that the president may be impressed upon to appoint some youth wingers of TNA and Jubilee and URP to see whether they can be very lenient with the judge. So until they see the composition of the tribunal, I don't think Justice Tunoi will go anywhere.
Should he? Should he just resign now and not wait for the tribunal?
But I don't think, there's also other things. A month ago, he wrote a letter resigning. When it went to the registry, he withdrew it. 6 months ago, he sat with the JSC and they agreed on a package for him to retire. When it was agreed again, he withdrew. There's a feeling within legal circles that, someone is remote controlling him, really.
There's also a feeling that this is linked to the succession of the Chief Justice, who is set to retire in June.
There's no chance that he will ever become a Chief Justice. There was no chance.
Why
he doesn't have what it takes to be Chief Justice. So he was never in the equation, right from day one. So when he says, this thing involves succession.
And the timing of it, now that we're heading into an election.
He's so lucky that he made it to the Supreme Court. Really. Trust me.
But you put him there.
Trust me.
And now you call him lucky? You put him there.
Trust me, it was luck.
So many people point the finger at you then.
No, it's the JC. There's a lot of things we consider when we are appointing. We look at regional balance, we look at men-women ratios, all these things. We look at, who comes from this region. Those issues,
All right.
So when he says, succession, what succession politics? There's
so
no
according
chance.
to you, he was never in the running to succeed Willie Mutunga as the Chief Justice?
0 chance.
All right. So you claim he was lucky, but there's some lawyers who have issue with that list of merit of judges who were interviewed for this position. They say Tunoi came 7th, Njoki came 13th. That's Justice Njoki Ndungu. And then Katharima was removed for, ethnic balance. Could you talk to us about that process?
No. Of course, this is confidential, but I can tell you on national TV that that's false. Tunoi did not come that number. Njoki didn't come that number. Katharima was not removed. We took number 1, number 2, number 3, number 4, number 5, number 6. Like that.
And those are the top 7.
And those are the top.
So it is not true, these allegations about, certain games being played with ethnic balance?
JSC does not play that, at least when I was there. And I can give you one example. When we were interviewing Baraza, Baraza and the second person, there was 0.2 difference. So there were people who were saying that, Baraza is a lawyer. Can we give the judge who is 0.2 lower than her? And we said, no. 0.2 is the difference. And it's a merit-based interview. And that's how Baraza became Deputy Chief Justice.
All right. And there's also that issue with Baraza, and she's speaking out and talking about how this process was fairly rushed, and saying that Tunoi should not face the same treatment she did on mere allegations.
No, I think it's for Tunoi to learn from Baraza. If Baraza was fired and a tribunal convicted her on the basis of pinching the nose of a guard, imagine someone who is alleged to have taken $2 million. He should run, really, shouldn't he?
Alleged, though.
Yes, alleged.
Innocent until proven guilty?
Yes, but but $2 million, that's huge. Even by our standards as lawyers.
Even by your standards as lawyers?
Yes.
That's huge, that's big. All right. Let's talk a little bit about Anne Waiguru and like your reaction tonight.
I'm happy for her.
Yeah.
The allegations were baseless. I think, the court brigade led by Raila and his group should really apologize to her. I mean, it was a vendetta right from the start. I mean, unfortunately, this is how Kenyans fight corruption. There's a lot of noise in barazas and public rallies. Someone is condemned, they are being heard. It becomes untenable for the person to hold office. You have to resign. When you leave the office 6-7 months down the road, you are found not guilty, but already the damage is done.
Okay. You are on record as saying that the EACC is no longer an independent office, has been reduced to a department of the Office of the President taking instructions. Is that still your statement today? And who would be giving instructions regarding, and this was right after the raid at Waiguru's home, who would be behind this and why?
I used to be a former chairman of the Kenya Anti-Corruption Commission many years ago. I resigned from that on my own principles. But I was making that point because there are many cases in our courts, some of them I'm involved personally, that should never go to court in the first place. Because there is no evidence, there is no crime. But because this government wants to create an impression that it's fighting corruption, it forces the Kenya the commission, to take people to court on Trump-up charges. Let me give you one example. The governor of Isiolo, I'm doing his case in court, he is charged with signing a legislation passed by the assembly of Isiolo. How can that be an offense? How can that be an offense? It's not an offense. I mean, if Uhuru can be charged with signing statutes, it will create an uproar because it's not possible. But how do you take a governor to court because he has signed a statute into law? The 90%, in my view, of the cases on corruption should not be in court.
Why?
Because there's no offense. These are trumped-up charges. Cases have been taken for propaganda. It's a PR exercise. All these cases that are in court are PR exercises. And let me tell you, during the last 20 years, what is the conviction or the success rate of corruption? Maybe 0.001%.
And so based on that, then we shouldn't be prosecuting a number of the corruption cases?
Kenyans should hold both the DPP and the Corruption Commission to a higher standard. There must be an audit. You must tell them that you have taken all these cases to court. What's your success rate? When your success rate is 0.009, how do you entrust
But it doesn't necessarily mean that the allegations against them aren't there. Perhaps it's the investigation process that is there.
No.
But it doesn't necessarily mean that all the cases that go before the court are trumped up.
It's a combination of the two. Trust me, I'm a lawyer and I see these things every time. There are so many cases that when you want to fix a governor, you tell them, take this case to him. There's no evidence. There's nothing.
So you believe Anne Waiguru was being fixed?
Absolutely.
By whom?
By the opposition and everybody who is against that. Let me ask you.
But you said
yes.
that it's been reduced to a department of the Office of the President.
But you see,
Anne
wasn't charged in court. It was just the investigative aspect.
Absolutely.